My first guest, Professor Jared Goldstein with Roger Williams University. Thanks for joining us today.
Thanks for having me.
I appreciate your having us coming into the studio with us here to break down the Masterpiece Cake Shop decision by the Supreme Court. It's been all in the news, this 7-2 decision to allow these cake shop owners to not have to serve same-sex individuals. But you had an interesting vantage point on this. You said this does not set a precedent to protect some sort of any constitutional right to discrimination.
That's absolutely right. What happened in the case is this cake shop owner refused to make a cake for a same-sex wedding because he said it would violate his religious beliefs to celebrate a same-sex wedding. And then the Colorado Civil Rights Commission found that the cake shop had discriminated against this gay couple because of their sexual orientation. The cake shop owner said, but it would violate his free speech rights if he had to make a cake that expressed a message that he disagreed with, and it would violate his religious freedom if he had to serve people to celebrate a wedding that he thought that violated his religious scruples. And when the case got to the Supreme Court, I think a lot of LGBT activists and civil rights advocates were afraid that the case would make a lot of new law by saying that, people who object to same-sex marriage on religious grounds don't have to serve customers who are going to participate in same-sex weddings, or that there was a free speech right on behalf of, say, people who make cakes, because when they make a cake, they're speaking in some sense, or maybe, and if so, then what would that mean for the hairdresser? Are they speaking? Are they celebrating and sending a message that they don't want to? Maybe they wouldn't have to participate in same-sex weddings if they didn't want to. What about the photographer? What about the caterer? And the court did not do any of the things that a lot of LGBT activists and civil rights advocates were afraid of. They did not say that there's a constitutional right to discriminate based on religious objections. What the court said was that in this case, in the specific facts of this case, Colorado had expressed a bias against the religion of the cake shop owner. So in this case, he had been treated unfairly, so they couldn't punish him for refusing to serve a same-sex couple. But in the next case, if that same couple, or if any other couple comes back to that cake shop and he refuses to serve them, then he will violate the Colorado law, and unless Colorado treats him unfairly, he will have to comply with that law.
So do you really think this is sort of a one-off scenario, if we will? Will we see this tested moving forward?
Yes, there will be more cases. There were cases before that didn't reach the Supreme Court, one involving a wedding photographer who refused to photograph a same-sex commitment ceremony. This was before same-sex marriage was legalized. There'll be other cases, maybe involving cake shop owners or florists, who say it violates their religious objections or their religious beliefs to participate in a same-sex wedding. And the case is likely to come back, but I think the court sent a signal that in these next cases, when, as long as the state applies the rules fairly and equally, because we have rules in Rhode Island, and as in many states, that prohibit discrimination based on race or based on sex or based on religion or sexual orientation, as long as those laws are being applied equally to everyone without any bias against religion, then everyone will have to serve all customers.
Do you think that that's been played out in the media? We talked a little bit before you came out here, really parsing it. But again, folks were very concerned, especially on the side of the couple, that this was going to set that precedent. Do you think this has been reported accurately?
No. If you read certainly the headlines, or if you go on to any of the CNN or Fox or MSNBC, they portray the decision as a big victory for the bakers. And it's true, the baker won this case because he could say that he had been treated unfairly by the state of Colorado in this case. But the court did not set a broad precedent. There's no holding that says that any time someone has a religious objection to serving a gay customer, that they don't have to do so. That's not what the court said at all. There's a lot of language in the decision that says when a company opens a business, they have to play by the rules. And the rules in Colorado, just like in Rhode Island, say you can't discriminate based on race, can't discriminate based on sex or sexual orientation. And those rules apply equally whether the owner is religious or whether they're not. And that still is the case today.
Now, were you surprised at the 7-2, or when you actually read what the rationale was from those joining the majority, did it then make sense?
You know, I teach a course on the Supreme Court, and this was one of the cases we studied the briefs for this year. And I ask all the students to predict the outcome for the case and to vote, or to predict each justice's vote. And nobody, including myself, predicted that the case was going to be 7-2 the way that it came out. Now, I did predict, as several of my students did, that the Baker was going to win. We thought it would be a 5-4 decision with the usual 5 conservatives and the 4 against the 4 liberals. But that isn't how it turned out. The 2 of the more liberal justices, Justices Breyer and Kagan, joined with the majority because the court was writing it as a very narrow decision that was limited to the facts of this case. That's what allowed the case to be resolved 7-2. But absolutely, if you read any of the media accounts, it makes it sound like there's a new rule that stores or businesses can discriminate against gay or lesbian customers if they have a religious objection, and that is just not the case. And everyone needs to, realize that the court did not create some new rule that if you have a religious objection to, same-sex marriage, that you can refuse to serve customers. That's just not the case. Not
the case. And again, that narrow interpretation, is that the reason from reading their decisions, again, joining to the majority in this sense to say this is a specifically narrow case and here's why, and this is why it's not broadly applicable?
Right. I mean, Justice Kagan wrote a separate opinion that Justice Breyer joined that explained why the 2 of them had joined the majority, and it laid out exactly this point, that this was a case about these facts, that the court wasn't establishing a broad rule. Now, there are 2 dissenters, Justice Ginsburg and Sotomayor, who thought the court should have ruled against the cake shop owner in this case. And then you had 2 more conservative justices who wrote another concurring opinion that says that they should have issued the broad ruling that everyone kind of expected or feared. But that decision, or that opinion, only got 2 votes.
Didn't end up happening. Well, it's interesting keeping an eye on this. You said the class was keeping tabs. Now, was school out? Did you have the class on an email list that you all talked after the fact?
Well, I asked them to submit their predictions. It's kind of like a Supreme Court prediction pool. There's a prize for the winner. They get a T-shirt with their favorite justice on it. Last year, the winner got a T-shirt that said, "Scalia is my spirit animal." But I asked them to send in their predictions before the end of the class, and if they can also, I also participate, so if they beat me, then they get 2 prizes. But so far, nobody has done that.
So Scalia is my spirit animal. Have you seen RBG?
I haven't seen the movie yet, although I saw RBG herself. She was at the law school, Roger Williams, where I teach this last year.
You haven't had a chance to see the movie yet, huh?
I haven't. I was going to see it at Cable Car, but it closed.
I believe it's at the Avon now, so you'll be able to catch it. I was hoping to pick your brain about that, because when I have a legal scholar in here, I want to pick your brain on all matters. And the next one I'd really like to do, as we talked a little bit before coming on, the potential for the President of the United States to pardon himself.
Yes. Well, the president, if you follow his tweets, has asserted that he has the absolute power to pardon himself. But that is contrary to our, long-standing legal tradition that no one is above the law, including the president. That's the lesson of Watergate. Now, to be fair, there's nothing in the Constitution that says one way or the other who the president can pardon. It says the president has the power to issue pardons. It doesn't say for whom he could issue a pardon, but we've never had a case where the president has pardoned himself. When President Nixon considered it, the Justice Department issued a ruling, back in the 70s that said that wasn't possible. Now, of course, no president has ever tried it, but I think it would be, contrary to our, long-standing legal tradition that the president is a citizen just like you or me and is subject to all of the laws of the country. He can't discriminate based on religion either, any more than the cake shop owner can. And it's interesting because the cake shop case may have some implications for the travel ban case, which is coming up that the court is deciding. If you remember, President Trump banned immigrants from certain Muslim majority countries. And the challengers there say, well, he's discriminating based on religion. And there's language in the cake shop case that suggests, the government can't discriminate based on religion. That's why the cake shop owners won. And the challengers to the travel ban are pointing now to that case to say, see, the president is doing just what Colorado did. He's targeting people because of religion. We'll see whether that makes any difference.
Interesting.
This year.
Again, the application from from this case to the travel ban. Now, you talked about having a pool, if you will, and being talking with students and seeing what might happen in the future. Do you think it could come to the point where the president considers pardoning himself?
Well, he might. I mean, I suspect that the political reaction would be so severe if he did it, assuming that the Republicans are willing to express outrage and do something about it. That's an open question whether they're willing to do that. I don't think that the reason he won't do it is because the Constitution says no, or because the courts would stop him. The political pressure is what's going to stop him. And to be fair, our system for, say, removing a president is mostly political. It's not legal. That is, it's not in the courts. The way to remove a president is through impeachment, and that's a political process. So it's always a question of whether Congress is willing to step forward or whether they see the political harm as being too severe.
Well, we'll see what happens moving forward here. Obviously, all eyes on the midterms and the composition of Congress now moving forward. But it's summertime. You are a professor at Roger Williams, of course. Research is on the plate. What can we expect to see from you moving forward?
Well, I'm working on a book that I'm hoping to finish this summer about the constitutional theories of different nationalist movements in American history, including the Ku Klux Klan, Christian nationalists, nativists, the Tea Party movement, and other groups like that have rallied around the Constitution as an expression of what they think the country is about. And people are often surprised to learn that the Klan, which of course our most infamous hate group in the country, has since its founding been focused on the Constitution. That in its first charter it expressed its dedication to support the Constitution. But what the Constitution has meant to the Klan over its decades has been, white supremacy, white rule, all these ideas that they read into the Constitution as the expression of what kind of country we are. But then you have Christian nationalists who read into the Constitution that we're a Christian nation, or the Tea Party movement that reads into the Constitution that we can't have government support for health care. One movement after another has looked to the Constitution to express its own ideas about what the country is about, and the Constitution often can function as what I think of as a magic mirror. They look into the Constitution, but what they really see is themselves.
Let's see what they want to see in it.
That's right.
And has the Constitution, you talk about these nationalist groups, has there been any instance where it's precluded sort of the existence or the rights for these groups to exist, but are all of them felt that they've been rationalized within the document?
Well, it's hard to say. I mean, everyone finds in the document something that they feel is like the truth about what the country is. Nativists think that the country was made for white Protestants, and so they think we have to exclude people who don't fit that mold because they're not fit for the Constitution. So it's been used. These kind of nationalist ideas of the Constitution have been used to exclude other people. Sometimes those theories have been used against the very people who they're advocating for.
And so when do we expect to see this, the publication of this book, Professor?
Well, I'm submitting the manuscript, I hope, by the end of the summer, so probably means 2019 before the book comes out, which is going to be called To Kill and Die for the Constitution. To Kill and Die for the Constitution will come out in 2019. I'm assuming will be used in a Roger Williams class of law. I hope so. I certainly hope so. Well, I appreciate your taking the time to come in again with this Supreme Court ruling to really break down the ramifications and the implications for it. Is there anything that we missed going over it? Not that comes to mind. I do think they've left for another day whether someone who makes a cake is speaking and protected by the free speech clause, or whether someone who is a hairdresser for a wedding is engaging in protected speech. But I think that the implication of the case is, even if they are, the states can still prohibit them from discriminating based on sexual orientation or race or anything else.
Well, we're going to keep a close eye on the Supreme Court and, of course, keep close ties to legal experts having here in Rhode Island some of the best. And I'd like to thank you for coming here into the studio. Jared Goldstein, thank you so much. Don't go anywhere. We'll be right back with our next guest here at the Navigant Credit Union Broadcast Center.